I'd like to introduce Bob Reese and Jim Love. And you want to come? Well, I think we're going. No, go ahead, John. You got something ready to say.
Sorry. It's sure hard to follow David there, but I think this is one Matt can do. But anyway, welcome into the breakout session here. We're going to have some very interesting information, especially from a couple of friends that I know of the IAOMT. But today we have Mr. Jim Love and Mr. Bob Reeves. And the topic is going to vary a little bit from what's on the handout. They kind of changed it, thought it would be something more appropriate and more timely, some things that are actually going on right now. So I think their topic is going to be about the moms against mercury versus the FDA that's pending in Washington, D.C. right now. So it'll be some up to the minute report. But about these, Mr. Love has a private practice in Tulsa, Oklahoma, and has published articles on legal, civil rights, and constitutional issues. Mr. Reeves is in private practice in Lexington, Kentucky. Both attorneys are also lecturers, members of the IAOMT, and have extensive experience in dental litigation. And I know they have been really great friends to many members, individual members in the association, in the academy, as well as of the academy in general. Just familiar faces, certainly every time that I've been here for the last several years. So without further ado, I don't know which one's going to start. Jim Love and Bob Reeves.
Is it on? Everybody hear me? I'm supposed to read the AGD disclaimer. Being an attorney, I have to modify it a little bit. It's asked me to say that I do not have a financial interest in a product in my talk or with any company offering grant monies for this continuing dental and medical education program. Most of you know I'm the attorney for the Academy, one of the attorneys for the Academy, and occasionally sell my legal services to the Academy. Let's get started. I wanted to open today's presentation, which should last 40 or 45 minutes, with a little story that I remember from the 90s, talking to Michael Ziff. Michael was a consultant to me in the very first amalgam litigation that I worked on, a case called Tolhurst versus the American Dental Association. And Mike actually came out and sat with us during a, as I recall, 1-week Dalbert Frye hearing, which was a hearing in which the court had to assess the viability of the scientific evidence we were presenting in support of our personal injury case. At some point following that case, in the course of handling my second case involving dental amalgam, I started reading FDA regulation. I had become interested in that because the issue of preemption, which I'll talk about later, arose in the context of the Tolhurst case. The preemption issue is one that was raised by the amalgam manufacturers in that case, and they asked that Dr. Tolhurst's claims be preempted based on the specificity of FDA regulation that pertained to dental amalgam. And we were fortunate enough to win that case, but I became very interested in FDA regulation, read up on it, and actually asked Mike at some point a few years later to allow me to seek to judicially force FDA to place dental amalgam in Class 3. And Mike, I never could get Mike on board with that. I was convinced I could do it. After several conversations with my new friend Bob Reeves became convinced we could do it. But one thing was for sure, I never could convince Mike we could do it. And I still remember Mike's words. He said, "Jim, you'll just screw it up." And he was playing with me a little bit. I tried not to take that very seriously, but he really kind of meant it. As my wife said, he was teasing on the square, because he really thought that in our effort to get this product placed in Class 3, that it would end up in Class 2. And that was a real fear for him. And the reason it was a fear for him is because he understood the consequences of Class 2 classification. And the reason he understood it is because he'd done his own research on FDA regulation, and he had held my hand as we fought the preemption argument in the course of the Tolhurst case. So he understood what that meant and what the consequences were, and if the product was classified in Class 2, what that would mean to personal injury litigation, state law consumer protections that existed, including Prop 65. And he didn't want me to cause this product to end up in Class 2. And so he never would advocate spending Academy monies on that enterprise. After Mike passed away, I frankly, in deference to him, never brought it up again. Never asked this Academy to support that kind of effort. Had, frankly, the same concerns. I didn't want to prove Mike correct in pursuing classification where the product ended up in Class 2. And so as far as I was concerned, it was a dead issue. But along came a guy named Charlie Brown. I think most of you know Charlie. And he sought the very thing that Mike feared. He sought classification, and he also sought a ban on amalgam fillings in litigation that he commenced on behalf of 11 plaintiffs. And I'm going to skip ahead a little bit. Charlie proceeded to mediation, which was overseen by a magistrate of the Federal District Court in Washington, D.C. The case was settled, and I think explaining the settlement is pretty easy. There was an agreement by FDA to classify mercury fillings on or before the end of July 2009, and there was an agreement to modify the FDA website to include some incremental changes that were more favorable to the position of our Academy than had existed in the past. I would take the position, and we'll talk about it more, that those changes were fairly modest and I think misleading, certainly ambiguous, but that was the agreement. At some point, Karen Palmer found out about the specific terms of that settlement very near in time to the date that she found out about it, expressed her objections first to Bob Reese and then to Mr. Brown, and Brown took the position that she was bound by the settlement that he had reached, and she sought new counsel. And so we're going to proceed this way. I'm going to introduce Karen Palmer. She's here today. She'll have just a couple of comments about her involvement in this case and how it ended. Then I'm going to turn the mic over to Bob Reeves. Bob was counsel of record at the outset of the FDA litigation, attended the mediation, was involved in an exchange of communications following the mediation in the settlement, and has a perspective on what happened here that I think is important to understanding the issues that we're going to talk about today. You may have seen some emails that Brown has sent out recently that I contend and will explain contain misinformation that I think you should know about. I'd like to explain our position. Brown has accused me personally of attacking his license, seeking to prevent him from practicing law, at least in federal court. That's not the case, and I'll explain why. And then he's also accused us of seeking more than is available in this forum, relief that he claims and that he has some support for this. Judge Hovell found that Charlie Brown's settlement achieved all that can be attained from this litigation. I take a different position. I'll explain that. If you have questions about that position, I'll be glad to answer them, either during this session or after. You're always free to email me. I'll be glad to answer any question. We're on appeal. Here's the style of the case. I didn't include the case number, but this is the style of the case. It's pending in the Court of Appeals in the District of Columbia. The brief was our brief, the opening brief, the brief in chief, was filed on Tuesday. We've already been through what I call a dress rehearsal. There was a motion for summary affirmance filed by the FDA defendants. That motion was joined by the other plaintiffs, and that motion was denied, which was a favorable ruling for us. And so I'll talk about that a little bit. So without further ado, let me introduce Karen Palmer. And I'll hand the mic over to her.
Thank you, Jim. As most of you already know, I continue to suffer every day from damage to my body, the result of handling mercury daily for decades. As my job as a dental assistant, now disabled. Currently, I am a plaintiff in a lawsuit involving the FDA. Once upon a time, there were several other plaintiffs, but no more. I believe because of some of strong-arm tactics and misguided loyalties, I now stand alone in this battle. I don't have all the answers. Nobody does. But I am certain that I was never coerced, for I have my own very strong convictions as to how and why I could not agree to the settlement and subsequent dismissal without proper disclosure of all terms and the true facts. While I admit early on to being caught up in the worldwide media blitz to the FDA website changes, I was still not entirely comfortable and had some reservations, largely because of the absence of addressing the occupational exposure in regard to the 266,000 dental assistants in this country. The first ones, truly, really, to be exposed and poisoned. I am so hopeful for the best possible outcome and extremely appreciative for all the continued support in this matter. Thank you.
Karen sent an email to Charlie and me saying, go get them, basically. And, sorry. And the next day, let's see if I can get this done. That one's next. The next day we had the mediation. I'm not going to go into a whole lot of detail of what actually took place in the mediation with the U.S. Magistrate, but I spent most of my time arguing with Charlie. And I want to explain a couple things right there. I had filed a suit at the request of SAMZIF against the FDA in 1993. We did not file a petition in that case because there was clear case law out of the D.C. Court of Appeals that we did not have to exhaust administrative remedies in a situation like this. Ultimately, the District Court of Appeals, where we filed the action originally, held that we had venue there, we were in the proper court, ordered us to brief it, and then they said that we hadn't exhausted remedies, which is just what we were relying on not having to do, and dismissed the case. And we filed petitions to ban mercury or to categorize it in Class 3. And the Class 3 basis for that is that anything that's an implant that stays in the body for more than 30 days, by regulation, has to be an implant. And it has to be in Category 3 unless they can find it safe. Well, in our minds at least, mercury clearly was not safe. The Dental Division of the FDA had requested the commissioner not consider it an implant, and he had denied that. So that was the basis for the lawsuit in 1992, and it was the basis for the petitions that came later. They were filed in late 93, if I remember correctly, and they were denied by the FDA. They're supposed to do it in 180 days. They can ask for 20 more. They took 3 or 4 years and denied it and said they were going to do things to warn about it, et cetera, but they did nothing. And like Jim, I talked to Mike and tried to get some interest in filing against the FDA again, and Mike was adamantly opposed to it. Unlike Jim, I didn't have enough sense to listen to him. And so I tried to figure out a way to get this done, and I urged Charlie for several years, from 2001, 2002, about in there, until he finally filed this litigation. And I gave him copies of everything we had and signed on as co-counsel with him. Now, the thing that I didn't know about going into the mediation was that I always viewed Charlie as an attack dog. And let me say this thing. I'm going to say some things about Charlie Brown that are not very complimentary, but I've got a lot of complimentary things to say about him too. If Mr. Brown had not petitioned the FDA in 2005 to have a joint panel meeting in terms of the safety of amalgam, we would have never had that historic meeting in 2006 that Mike Fleming sat on as a member of the panel. And the vote was 13-7 against the FDA's position, basically, that amalgam was safe. on 2 separate votes. And that has great implication now that Jim will tell you about later, but it's almost impossible for the commissioner now to say, well, it's an implant, but it's safe, and we're going to put it in Category 2. But the other thing that I didn't understand about Charlie, at that meeting on September 6, 2006, Charlie stood up at the start of the meeting without any approval or recognition by the FDA people there, and proceeded to give them HELL. He just blasted them all over the place and told them what idiots they were. And I agreed with him. And eventually they called the security guard in, as I remember, to get Charlie to sit down and be quiet. And so when I went to this mediation, I expected more of that behavior. But instead, Charlie basically wanted to be friends with the FDA and did not want to push them. And as far as I'm concerned, we left quite a bit on the table. We could have gotten additional warnings. In fact, at one point, I had the other side, the FDA, to agree to an additional warning, and the magistrate. However, Charlie didn't want it in there, so it didn't go in there. And I also pushed Charlie to make the FDA release this to the press, and they were really upset about that. And I pushed for it, and they said they'd go see if they could have a press release. And Charlie said to me, Bob, we don't want that because we don't know what they're going to say. And I said, Charlie, we've got the United States Magistrate here. We've got Judge Hovell, who's already read them the Riot Act 3 weeks beforehand. 2 weeks, I guess it was, beforehand. And she had, the FDA at that hearing on May 16th had basically said to her, we need time to classify this. And she said, you've had 32 years. What do you want, basically? I'm sending you to mediation. And she picked up the phone. Apparently, I wasn't in the courtroom, but she picked up the phone, called the magistrate, and said, I got a mediation set May 29th. And I went to that mediation for the sole purpose of supporting Charlie. And instead of supporting him, I found myself arguing with him, negotiating with him, and not with the FDA. And I kept pushing for this announcement. The FDA came back in and said that their representatives, and Randall Lutter was the deputy commissioner, was the highest ranking person there. Along with the Justice Department attorneys and their own attorneys and other representatives. So they had about 6 or 8 people there, and I've never seen such a cowed group. They were scared of us. And they came back in and they said they couldn't have the press release, but they could, because they only give out 1 press release a month, 12 a year, but they could put it out on a newswire under their auspices. And I said, how many people is that going to go to? And they say about 400. And I said, that's good. Well, the whole thing collapsed, in my opinion. I was not happy. Charlie said I had buyer's remorse, that he hugged me, etc. And I went home deciding to not do much at all about this. I wasn't going to talk to anybody about it. And I started getting phone calls from people who were plaintiffs and people who were non-plaintiffs who were not happy with this and expressed their unhappiness based on the limited information they had. And I sent an email to Brown asking, do you have authorization from all the clients to settle this, as you did? Now, that's an important question there, because during the mediation, I contacted Sandy Duffy, who was the president of Consumers for Dental Choice, who was Charlie's employer, paid for the litigation, and was a plaintiff. I called her twice. Charlie would not talk to her. I also called Bernice Kalura, who was on the board, and talked to her about the problems I was having there at the time. So I sent this email to Charlie the next day, said, do you have authorization? And he never really answered that. But I sent that email at about 11:30 in the morning, and by 7:40 that night, I have a fax that's not up here now, but showed that Brown had signed his signature to a settlement agreement. Actually, I think it was the dismissal at that point in time, and faxed that to the FDA attorneys. So 8 hours after I said, do you have client authority, Charlie basically puts the case on ice. And then a half an hour later, Charlie sent an email to the clients telling them in general terms about the settlement, but not really much specifics. He called Karen, telling her what a great victory it was, and then she found an email from him, which again did not reveal that he'd it never revealed to any of us at that time that he had fully executed a settlement agreement and a dismissal. And he had done those on Friday night. And then, unbeknownst to me or anyone else, on that evening, Sunday evening, he filed a stipulated dismissal in the PACER system in federal court. And I didn't find out about that until 5 days later, when it was suggested to me by Sandy Duffy that I better look on PACER because it looked like the case had been dismissed. Karen sent an email saying how great this is to Charlie. And then, and I can't tell you right now quite why, but I decided to call Karen because she had called me earlier expressing some concerns about this. And so I called her, and I've asked her this. I did not try to coerce her at all, but I just asked her, how do you feel about this settlement? And she said, haven't you read my email? And I said, no. And she said, well, I sent it to you 10 minutes ago. So I read her email, and I said, look, you need to pass that on to Charlie. You need to tell Charlie this and not me this. And so she sent an email to Charlie, and in a sense, all hell broke loose. On that, the 3rd, he sent an email that we'd settled our lawsuit to all the clients. On the 5th, now this is interesting. On the 5th, Sandy Duffy sent Charlie an email saying don't do anything. Don't conclude the settlement of this case. And Charlie responded to her, didn't say that I've settled the case, it's over. What he said is, you don't have the votes. And on June 6th, Karen learned for the first time that Charlie had dismissed the case because I found out on the PACER system that the case had been dismissed. It did not show it had been settled. There was no settlement agreement, and settlement agreement wasn't entered until 2 days later. But I sent an email to Charlie, and I think I sent a carbon copy to Karen and maybe to all the other plaintiffs, telling them that Charlie had dismissed the case on an agreement signed May 30th. It was electronically entered on Sunday, June 1st. And on June 8th, we found that he'd entered the settlement agreement. Now, the interesting thing is we had meetings and talks with Charlie. Charlie fired me in the first place. He said, you're fired. He said that early, I think after Karen talked to him, he called me up or sent me an email and said, you're fired. You're not their attorney anymore. And I said, Charlie, you can't fire me. I represent the plaintiffs. I don't represent you. Wasn't hired by you. I'm co-counsel with you. He said, no, you're fired. Well, if you look at the fee agreement, the fee agreement says Robert E. Reese and I, Charlie Brown, will represent you. And I did not accept the fact that he fired me. During this time frame, Charlie did one thing which I consider highly unethical. I've never filed a complaint with the D.C. Bar Association, but to this day, it disturbs me. I was sending emails to Charlie telling him what I thought our position should be, how we should deal with this situation. And he would send them, he would forward them to the attorneys for the FDA and say, look what an idiot Bob Reeves is. He's trying to destroy our wonderful settlement. Now, I think that at the very least, Charlie would get a written reprimand, if not lose his license for doing that, if I brought it up with the D.C. Bar Association, but I have not done so. And then he sent Karen's fee agreement, I believe, to the FDA, and he sent a lot of her other information. And one of the things you've got to understand here is the Bar Association and the courts put a burden on Jim Love, me, and every other attorney not to get any situation where there's a conflict of interest. That if there is a conflict of interest, you have to withdraw from the case. And in fact, during this period of time, Charlie and I had a discussion, more than one discussion, and emails where Charlie said, Bob, if we don't settle this and all agree, then you and I are both going to have to get out of the case. And I said, yeah, I think you're right, Charlie. We'll both have to get out of the case because that will create a conflict of interest because we both represent all 11 of these plaintiffs. If the plaintiffs don't get along, we've both got to withdraw because we've both had confidential information between us and those plaintiffs. And that attorney-client privilege is confidential. So during this period of time, finally, Karen got fed up and called me and said, Bob, I'm not going along with the settlement. We haven't reached any kind of compromise with Charlie. I want you to represent me. I want to raise this issue. And I said, Karen, I can't do that. There's a conflict of interest. I cannot represent anybody in regard to this, so I'm going to refer you to another attorney, and I suggested she call Jim Love, and I think I actually got her on the phone with Jim Love, and I bowed out of this case at that point in time. Now, there's a lot more I could give you, but I've taken a lot of time, and I want to let Jim explain what's taken place then and since then.
One of the things I teach you when you go to law school is you're part of a very special process, a process that requires integrity. And if they said it once, I think they said it every day, you will act with integrity. You will follow the rules of professional responsibility. You will be ethical. Your clients may not be ethical, and your adversaries may not be ethical, but by God, you will be ethical. And it's a very important part of the process. I had to take a bar exam, but separately, well, I touched the, pardon. I think it is the FDA. Charlie. There. The integrity of the process is important. I'm in a self-policing profession where we're expected to not only behave ourselves but report conduct where our colleagues don't behave. And that's emphasized over and over again. One of the things that we can't do, I hope you understand this conflict of interest idea. It's very important in my profession. I think most of us know what a conflict of interest is. But it's so important in my profession that every time I get a new client or every time I get a new case for an existing client, I send around a conflict memo. And so does every other lawyer in our firm. And the reason we do that is even though a new client comes to me and I don't recognize and have never represented his or her adversary, it's possible that one of my partners or one of my associates has represented that other partner or other party. And if that's the case, I decline representation for my new client or in that new case. I back out and they have to go get new counsel. It's a very important part of the process. That conflict memo serves a lot of administrative functions. We set up a file, we assign a number, we acquire contact information, and we set up billing. But the main reason we send the conflict memo around is to assure ourselves that we don't have a conflict of interest. A local, let me show you just how important this conflict idea is. A local firm, very reputable firm, one of the most reputable, I would argue, in Tulsa, got involved in a bankruptcy case. I don't know much about the case, but they believed that they did not have a conflict of interest for whatever reason, and they advocated that, and they got an adverse ruling from the district court, and they appealed it. I think they sought a writ of mandamus, if I understand the story. In any event, the short story is that they did not prevail. The court ultimately found they did have a conflict of interest, and as an award for losing that case, the court sanctioned them $700,000. It is a very important concept, and the reason why is pretty obvious. Let's take this case. If you litigate, again, one of the black letter rules of professional responsibility is you may not advocate against a former client in the same case in which you represented him. And I think the reason why you can't do that is pretty obvious. You've got a client litigating against someone that formerly represented her is at an extreme disadvantage. Presumably they've exchanged evaluations of the case, they've exchanged the desires they hope to gain from the case, they've exchanged private confidential information, private communications, attorney-client agreements, terms of representation, and we don't want that information being used against that client in litigating against an adversary. So let's look at what happened in this case. Charlie Brown represents Karen Palmer. At some point, he realizes that she's going to go a different direction. Charlie recognized in his conversations with Bob Reeves that he had a conflict of interest, and in fact represented that both he and Bob would probably have to withdraw from the case. In fact, that's not what happened. Charlie continued to litigate against his former client in violation of the D.C. rules of professional responsibility. At some point, he took Karen's communications with him and the attorney-client letter of representation that she had signed and sent those to counsel for FDA. You're beginning to understand how you're at a disadvantage to litigate against your former attorney. That's why we have the rule. You can't do that. And so it was at that point I realized I wasn't completely uncomfortable with Charlie litigating in the case. I assumed at some point he would file a motion to withdraw, but in fact he did just the opposite. He began to file briefs advocating against the relief that Karen Palmer was seeking, which in the context of this case was the vacation of the dismissal that he'd filed in this case. Okay, so I felt it was my responsibility to take some, in fact it is my responsibility ethically, to take a position. I've got to advocate Karen's case. There is an attorney, I've got to read this quote because it really seems to fit here. I've repeated it several times in the course of my career. I don't know if any of you ever had a chance to watch the Ollie North Senate interrogation, but Ollie North was represented by Brennan Sullivan, and Brennan came up with a very famous line. The chairman of the Senate interrogation committee was getting tired of Mr. Sullivan's objections, and he finally suggested that Mr. Sullivan quit lodging those objections and allow Ollie North to testify for himself, at which point Mr. Sullivan said, well, sir, I'm not a potted plant. I'm here as the lawyer. That's my job. And that made front page news the next day, if you remember that quote. I'm not a potted plant. Well, I'm not a potted plant either. My job as the attorney is to advocate Karen Palmer's interests. And if Charlie's going to violate, not withdraw from the case, and in fact violate confidentialities and advocate against her, I felt like I had no choice but to file something called a motion to disqualify. And I want to clarify exactly what that is. That asks the court to enter a finding that Charlie has to withdraw from the case. It doesn't do anything more. I didn't ask for his license. I didn't ask that he be prevented from litigating in federal court. I didn't ask that his reputation be ruined. I didn't ask for any of those things. I asked for what I consider to be the smallest amount of relief that we could realistically expect to receive. I think I could have asked for much more. I did not file a complaint with a D.C. bar. If I wanted Charlie's license, that would have been the appropriate procedure. But our motion was not filed with the Bar Association. It was filed with the Court of Appeals. Now, I asked strategically that the matter be referred to something called the Committee on Admissions and Grievances, and there was a reason for that. If you read the local rules, that is the investigative arm of the court. And I was anticipating an argument here that I actually received. In his opposition brief, Mr. Brown told the court correctly that you're a court of review. You're not a fact-finding court. You're not an investigative body. And he's right. But if he read the rules, he would find that the investigative body in connection with ethical complaints is this committee. So that was the reason. It's not that I was seeking sanctions beyond his disqualification. Now, some of you may know that Charlie this week withdrew from the case. He knew that the outcome was inevitable, I would suggest. He knew we were going to prevail in our motion. And there is a gentleman named James Heffron that has substituted in as counsel for the other plaintiffs. I have not withdrawn my motion to disqualify as moot. The reason being, I think that Charlie's withdrawal is a capitulation of the motion to disqualify. So I'm going to continue to ask for an order, and there's a method to my madness. I want the order because if Charlie ghostwrites or continues to informally or formally advocate against Karen Palmer, I want the ability to seek a contempt sanction. And I won't be requesting that unless he actually continues to advocate. So I wanted to make that clarification. These emails that Brown has sent around say that I'm asking for much more than I'm actually asking for, and I know that's generated some rancor from not only within the academy but outside the academy. Okay. Now, can we get more relief? What's wrong with Class 2 classification? Do we think that FDA is going to classify in Class 2? The answer is an overwhelming yes. I think they're going to classify in Class 2. All the reasons why would take too long to explain. I think we're limited on time, but I think there's overwhelming evidence, not the least of which is their proposed rule from 2002 in which they suggested that they wanted to classify in Class 2. I'd like to not see that happen, and I've got at least two reasons I'd like to discuss today. I think there are more. At some point I enter into the realm of speculation. I think the Class 2 classification, depending on what the special controls are that are applied to mercury fillings, may well change the relationship between dentist and patient. But I'll agree with you that I don't really know how that's going to work out. I could probably evaluate it better once I know what the proposed special controls are going to be. What I do know is that two things are almost certainly certain to happen. The first one is that this doctrine of preemption is almost certain to kick in. There's a very famous case called Associated Amalgam Manufacturers versus Stratton that was filed in federal court in David Kennedy's backyard, San Diego. The district court found that personal injury claims, it was a Prop 65 case, but the idea is the same. Personal injury claims and Prop 65, the amalgam manufacturers argued, were preempted by FDA regulation of mercury fillings. At that time, it's the same today, at that time, amalgam fillings were not regulated as a kit. They were regulated by their constituents. Mercury was in Class 1, alloy in Class 2. The appellate court, in the context of the Stratton case, was the Ninth Circuit Court of Appeals. The Ninth Circuit reversed and said, really, we're basing this notion of preemption on inaction by FDA, not action. We don't think that equals preemption. So they sent the thing back. Prop 65 was saved. For those of you that don't know what Prop 65 is, David Kennedy knows. Dentists have to reveal that they're using mercury, and mercury is known to the state of California to cause birth defects and or cancer. That's what Prop 65 says. And there are a whole list of chemicals that have to be revealed by gas stations and such, depending on what chemicals they use, and they have to reveal that these chemicals are known in the state of California to cause reproductive effects and cancer and or cancer. So Prop 65 is a helpful consumer protection that I'd like to see saved. Personal injury lawsuits against amalgam manufacturers have a tremendous benefit for consumers and apply a lot of pressure, I would argue, to U.S. policy, FDA policy, ADA positions, and certainly manufacturer warnings. So that's not something I want to see go away. I think from my standpoint, people that are injured by amalgam fillings, and I'd contend there are many, I think most of you would agree with me, ought to have the right to seek redress against their dentists or against amalgam manufacturers. So that's something we'd see go away. A second consequence of Class 2 classification would almost certainly be the disappearance of the Burns versus Kerr doctrine. And I know Dr. Cole talked about that this morning. I'll be glad to talk about it more. But the benefit of the Burns holding is that the Kerr's warnings, which extended only to mercury, not to mixed dental amalgam, were found by the court by implication to also apply to mixed dental amalgam. So while that was a horrible outcome for Dr. Burns, it was a wonderful argument for this academy, because we could now say that if Kerr is calling mercury a neurotoxin, we can also assume that mixed dental amalgam is a neurotoxin. And what's even more, if you know something about the law, is that the learned intermediary doctrine requires dentists to disclose manufacturer warnings and all their implications to their patients. So if Kerr meant mixed dental amalgam, then the dentist has to reveal that mixed dental amalgam is a neurotoxin. That, again, Dr. Cole very insightfully said, we're not getting that message out. That's a wonderful tool for us to use, and it sure is. But if FDA applies its own regulations, even if they only extend to mercury, I don't know that we can immediately assume that Burns versus Kerr continues to have application. What did FDA mean by that? Is it a different meaning? And for that matter, how will that issue ever be litigated? Because no one, unlike Dr. Burns, no one's going to be bringing personal injury claims, because those claims are now going to be preempted. So I hope you can see that Class 2 classification has a lot of very important negative ramifications for our movement. The question remains, can we get mercury fillings classified in Class 3? And that is a big unknown. I think Mike Fleming would probably argue, no, that's not relief that's available from the court. I take a different view. It's one that differs. I think Charlie's view is that all he could ask for is classification. And I would be the first to agree that in the context of a court forcing an administrative agency to act in conformity with its congressional mandate, the remedy is to seek to force the agency to act. Courts are almost always unwilling to go farther. I can cite a couple of examples where they've gone farther, but you have to look for them. It doesn't happen very often. I think mercury fillings are different. I think the reason why Class 3 may be available to us is because it has a very unique regulatory history. And that that's a complicated subject. I've discussed it at length in our public comment. I'd encourage you to take a look at that if you need more information about it. But the long and short of it is that, as Bob explained, implants have to go in Class 3. The commissioner has the prerogative to take an implant out of Class 3 and place it in Class 2 if the commissioner can assure us with written findings signed by the commissioner that the implant is generally regarded as safe. On at least 2 occasions, the FDA has found just the opposite. In 1998, if I have my year right, the FDA found that mercury fillings could not be generally regarded as safe, and essentially the joint panels that met in September of 2006 reached the same finding, voting 13-7, not to endorse the findings of the FDA white paper. So we've got a pretty good track record, in fact an uncontroverted track record in this case, that the FDA commissioner no longer has discretion to take this implant out of Class 3. And so my argument to the court is going to be, if I ever get that chance, is going to be that FDA no longer has this discretion. A court can force an agency to exercise this discretion, but placing this product in Class 2 at this point is further recalcitrance, furtherance of the 33-year delay that has been associated with this product. It is no longer available. And while the court may not be willing to enter into a scientific controversy, courts are generally very willing to enter into legal controversies. And so that's the argument. If we're not successful, I'll apologize in advance. But I think the benefits of 3 and the lack of benefits, in fact the detriments of Class 2, make this exercise worthwhile. Okay, let's go back very quickly. I'm just about finished. Let's go back to the handling of this settlement. I've put all the relevant communications in a bullet. I did these bullets. The mediation was held on May the 29th. Mr. Brown signed the settlement agreement with FDA counsel on May the 30th. So sometime between the end of the day on the 29th and the end of the evening on the 30th, Mr. Brown consummated, executed a settlement agreement that was only thereafter distributed to interested parties. You didn't see any attorney-client communications in between the end of the mediation and the signing of the settlement agreement. One of the hard and fast rules of being an attorney is that clients settle lawsuits, not attorneys. You didn't find any communications between reaching the settlement and signing the settlement. Another right that clients have is to review and sign the settlement agreement. Karen Palmer didn't know there was a settlement agreement and certainly didn't know that it was signed by her attorney and not by her until several days afterwards. There are communications that arise. There's a letter or an email of congratulations that was sent out on June the 2nd. And one of the lines in that is, "How brilliant are you, Charlie?" She doesn't specifically say, "I endorse the settlement." In fact, she was feeling just the opposite, because within 2 or 3 hours, she'd called Bob Reese, written to Bob Reese, and expressed her rejections. And that very same day, sent a different email to Charlie Brown expressing her objections to the settlement. But the point is, you can't get settlement authority after the fact. You have to get it before the fact. By the time that Karen Palmer had talked to Bob Reeves and had an understanding of the specific terms of this settlement, not only had the settlement agreement been signed, but the case was dismissed. That's not the way this works, folks. You got to have settlement authority. Now, there's been arguments about ratification. That goes into a different realm. Can you approve a settlement after the fact? Yes, but it's a completely different analysis. Now you've got to have full knowledge and intention to endorse the settlement previously entered into. Did she have full knowledge? No. Did she know the settlement agreement had been signed by her attorney? No. Did she know the case had been dismissed? No. Did she understand that any measure of congratulations might be used as evidence against her as an endorsement of the settlement? No. So our argument to the Court of Appeals is that this is not a delegation of authority and is not ratification. This is a very complicated lawsuit. I've just touched on some of these concepts. The doctrine of preemption is very complicated. I had never encountered the doctrine before the Tolhurst case that I was handling back in the early 90s, and when I found out just how complicated it was, I almost called Dr. Tolhurst and told him to forget it. because I was going to have to become an expert on FDA regulation, and I really didn't want to spend the time. But I did it. I learned about it. It's complicated. I wish I could tell you more about it. But in its essence, it just means these personal injury claims and consumer protections are going to go away. It's a real fear I have. I communicate a lot day to day with our executive council, and specifically Rick Shannon, who, God bless him, has to talk to me sometimes 2-3 times a day. And I know he gets tired of it. But the idea of having a legal liaison for this academy is he can then go back, explain this to the executive council. I can go on and do legal work without the need to call 10 or 12 different people, and they can stay abreast on what I'm doing, why I'm doing it, whether I'm staying within the scope of my employment, and keep a handle on whether my fees are reasonable. And Rick's done a very good job. Yes, Rick. Well, I think Bob can answer that better than me.
There were clearly reservations by other people, and several of them, including the Consumers for Dental Choice and one other individual, and maybe one besides that, expressed concern. Karen talked about strong arm and coercion. Charlie sent an email to Karen telling her that she was going to lose her house, all her savings, anything she had. Asked her if she told her husband that he was at jeopardy for losing everything with her if she followed the course of opposing this settlement. And he accused me of coercing her in this thing, and in fact it was just the opposite. And I think there's good reason to believe that Charlie did the same thing. I know he did it with one individual who was going to come over and ask Jim to represent him, and or her, and Charlie called this person, woke them up in the morning and told them they were going to lose everything they had, etc., and promised them the moon in terms of what was going to happen. And with a lot of these people, he said, we're going to get it in Class 2. They don't know what that means. I mean, classification by and of itself in Class 2, the thing about Class 3 is it requires the manufacturers to prove the safety of their product, which they can't do.
Let me say one more thing. Dr. Margolis had his hand up, but let me say one more thing. If this product goes into Class 2, and if I can't get this settlement undone, then the only recourse we have is to seek judicial review of the decision to classify in Class 2. The problem with that judicial review is you use the lowest standard of appellate review available. It's called abuse of discretion. If there's any justification for FDA's decision-making, then that's probably going to be deferred. It's a very deferential standard. So one of my aims in handling this litigation and taking the initial question back to Huvel is to ask her to sit not as a court of review, but as a court considering the worthiness of our request to compel FDA to act within its discretional mandate. Do you have a question? Well, thanks for your comments, and I hope you understand that going back to these crazy ethical rules, I'm not allowed to talk to the other 10 plaintiffs. That doesn't mean that people don't bring information back to me. John Wilson told me at lunch he talked to Amy Carson. Amy Carson is the president, or at least the top official, of Moms Against Mercury. And John said he talked to her extensively, and Amy Carson said, I sure didn't give Charlie authority to settle the claim of Moms Against Mercury. The problem is pervasive, and one that really was addressed by Charlie in his opposition papers. He said, I've worked with these people before. I'm not sure if he understood what he was saying. I've worked with these people before, some as long as 12 years. And they defer to me. They expect me to go out and do these things without their permission. Well, That's not going to match up very well with the rules of professional responsibility that require you to get specific authority, and they underline it and they italicize it. Specific authority, not some general authority, not some communication that took place 10 years ago. Specific authority to settle this claim. Rick. But, by the way, the letter from Brown to Palmer threatening her with financial ruination if she goes forward is an email format, is an exhibit to our district court papers. I mean, there's no question that this strong-arming occurred. There's no question about what the threats were. It's completely sophistic to make that threat. There's no financial detriment that I see that can arise out of further litigation, especially where the IAOMT is backing her effort, as is the case here. There's no threat that attorney's fees are going to be awarded. There's no threat that significant court costs are going to be awarded. And so Charlie Brown knew as an attorney that none of these claims were available, no financial ruination was going to occur, but he made those threats anyway, and he did it more than once. Yes, ma'am. That's my primary concern. The terms of the settlement were only that FDA would classify by a particular date, the end of July 09. There was no indication in the agreement where FDA would classify, and as I've told everyone, if at the end of July FDA decides to classify this in Class 3, they don't have to tell me I'm fired. I'll know that's the case. There's nothing else to do. The case is over, and all the relief we're seeking has already been obtained. I don't think that's going to happen, and neither does anyone else. John? Here, John.
I come at this from a different source as a staff coordinator for a series of congressional hearings. Staff coordinator for a series of congressional hearings. Under questioning from Congressman Dan Burton, the FDA representatives did indicate if we have to classify today, it will be Class 2. He went on to say, but we could add special conditions. But having read those special conditions that they intend to use, they're nothing. They're meaningless. As far as the FDA is concerned, this would just put the whole issue to bed. It's Class 2. There's practically no problem. There's nothing more to argue about. So fighting against Class 2 is exactly the right thing to do. We've got to either get this in Class 3 or ban it.